Okay, so good afternoon, everyone. You are welcome to the Ghanaian Association of Ottawa Community Impact Series. And today we have Kehinde and Taiwo Olalere. So they are from Nigeria descent. So if Kehinde and Taiwo in the Ghanaian palace will say Oko and Akwete, or we'll say, yeah, so that's it. They are twins. So as you can see, they are twins in the law. They are barristers and also immigration lawyers. We have 1 hour, so we have few announcements or things that we should note. Please, if you have questions, start putting it in the comments box, because we have just 1 hour. They would have a presentation, and afterwards you have time for questions, but you might not have the time to ask a question. So questions shouldn't be personal, so don't ask personal questions. They will not answer questions that are personal because of privacy and other issues, and it takes time to understand anyone's personal circumstances before you can give advice. So please refrain from asking personal questions. If you have personal questions to ask, you can book time with them afterwards, and then so that they can actually give you a tailored response. And then, yeah, so basically, I think this is the announcement. You have 1 hour, and exactly 5 would be ending the session. It's being recorded, so you can watch later on. So please start putting your questions down, and then we'll take it for first come, first serve. So at this point, I'll yield the floor to barristers Kehinde and Taiwo Olalere from Olalere Law Office. Thank you for joining us. Thank you. You can share a screen, or you can take us through the session. Thank you.
Thank you so much, Samuel, for that kind introduction. We're immigration lawyers here in Ottawa. The law firm has been established for about 21 years. We've been lawyers since 2004. Yeah, it's going to be 22 years this year. So this is what we do for a living, and our immigration is our passion. Everybody has their own hobbies, but our hobby just happens to be our line of work, which is just immigration. So we live and breathe immigration every day. Like, it's just something that we are passionate about. And for us, it's just not work. It's something that we love doing, and we love making a difference in people's life, helping people achieve their dreams, their goals, their aspirations in this land. So I think this land belongs to all of us, and we have the right to partake in it fully. We have the right to partake in it, and immigrants built this country. All of us are immigrants. The only people that own this land are the First Nations people, the Métis, the Aboriginal people, and we have to recognize that we are on their land as well too, and we do recognize it. So thank you again for inviting us. So I'm Kehinde Olalere, and I'm Taiwo Olalere, and basically what we've tried to do today, we think we wanted to sort of approach it in a way that maybe the first 30 minutes we'll talk about different topics that I think may be of interest to the community. And then maybe the first 30 we do that. So it's now 4:04. So the next 26 minutes we'll try to touch on some various things that we think may be of interest to the community, and then maybe the last 30 minutes we'll open it up, and then so that you can have the opportunity to ask questions. As Samuel eloquently said, we'll be able to provide general information on this session, but we can't answer individualized questions because of confidentiality, solicitor client privilege, and stuff like that. So, and if we take time to really understand the person's situation, best thing to book a consultation. We'll leave our contact information at the towards the end of this seminar. You can always reach out to Samuel too. He has our details and stuff. So I'll yield the floor to my brother to start off.
So thank you, everyone, and thank you, Samuel, for inviting us. We really appreciate that. He has been the one, pursuing us, and wanted today to happen. So I'm very happy about that, and we are very happy to be present here. So we're going to be talking about some topical issues that are in the field of immigration now that you can see that's now being, talked about in the news, and in public. The first one deals with Bill C-12. Bill C-12 was a legislation that had been, a bill that was debated for several months, introduced under the Trudeau government, but finally passed under Prime Minister Carney's government. So it officially became law in on March 26, 2026. It introduces very strict new eligibility criteria, and some refugee claims are now no longer referred to the Immigration and Refugee Board, to the Refugee Protection Division. So what are those refugee claims or asylum claims that are no longer eligible to be referred to the Refugee Protection Division? The first one relates to the 1-year bar. I always call it the 1-year bar, the 1-year deadline. Those that are, entered Canada after June 24, 2020, they've been here for at least 1 year. They can no longer be referred if they made a refugee claim after 1 year of entry. They can no longer be referred to the Refugee Protection Division. They will be found ineligible. That's a key word, ineligible. And it's more like a calendar cutoff, right?
Yes.
More like a calendar cutoff. You enter after June 24, 2020, you stay here for 1 year, and then after that you make a refugee claim, you'll be found ineligible. If you came to Canada, just for a visit, after June 24, 2020, and then you stayed for 2 weeks, just 2 weeks, and then you return back to maybe Ghana or Nigeria or South Africa, and then a few months after, maybe 11 months after or 12 months after, you come again, you come to study now this time around, and then you complete your program, or even in the midst of your program, you then apply make an asylum claim, and the first entry is what they'll be using to calculate it, the time you came to visit. Can you imagine that? The first time you came, you just came for 2 weeks, and then you left, and then you came back again. So the first entry is what they'll be using to calculate it. And if it's been more than 1 year since, your first entry, you'll be found ineligible. So that means you won't be eligible for to have your claim referred to the Refugee Protection Division. So what then happens is the next question. Usually when this happens, okay, before they make that ineligibility finding, sometimes, before they make that ineligibility finding, they will issue you what we call a procedural fairness letter. We lawyers call it PFL letter, acronym. PFL letter, procedural fairness letter. They will ask you to explain yourself. See, we look at our records. We see that you entered Canada. Your first entry was on this date. Can you please confirm to us, are we right? Are we correct? Because we believe you may be caught by this legislation, this BC-12 legislation. When you get that kind of letter, it's important to immediately seek advice of a legal counsel, a lawyer, because they will give you a very strict deadline to reply to that letter. So it's very important to seek advice from a lawyer so that you can meet that deadline in responding to that PFL letter, that procedural fairness letter, because it can have influence later on your procedural rights later. So let's assume you then meet with a lawyer, they look at it, they help you to respond to it, and then at the end of the day, you were refused, and they're still found ineligible. Then you have to then decide, okay, what are my options? The first option you have is you could go to federal court to challenge that ineligibility finding, because they're basing it on a calendar cut-off. They're not really considering the merits of your claim. Whether you have a well-founded fear of persecution, they're basing it on just a calendar cut-off. After June 24, 2020, that's when you came, you've been here for 1 year, you're cut off. We're not even going to consider your case.
You haven't even been here for 1 year, you went back and you came back
again.
But your first entry was
just, a while ago. So it's very important that when you're then found ineligible, you consult a lawyer, because you have very strict deadlines to go to federal court to challenge that ineligibility finding. Remember I mentioned earlier that some of you may be offered a PFL letter. Some may never be offered a PFL letter. The officer may just decide, you know what, they'll meet with them and say, we think you're ineligible. When did you come in? Oh, yeah, I came in on so. They verbally have that conversation and then they issue that ineligibility letter. From that date, you have the strict deadlines to go to federal courts. You don't have much time. So consult a lawyer immediately. Make sure you mention to the lawyer, you'll be found ineligible. What are my options? So one option is to go to federal court. So you challenge that one. Of course, because of the way that policy, that law is drafted and the policy that is underneath it, you're still able to apply for a work permit, right? So that ineligibility letter with other things, you may be able to use that to apply for a work permit while you're waiting for the outcome of that federal court case. That's number one. Number two, because you're found ineligible, you may have the option of what we call a pre-removal risk assessment application. It's similar to a refugee claim, but the only difference, there's a few differences there. With the refugee claim, if you're refused, you can go to the Refugee Appeal Division. If you're refused at the Refugee Appeal Division, you can go to the federal court. So there's two layers to remedy the issue. But with a PRA, if you're refused, you can only go to the federal court. Number two, with a refugee claim, you will appear before someone that we call a panel member to hear your case. You will physically be present or through virtual, just like we're seeing each other, through virtual hearing. You have a hearing before a panel member who will listen to you, consider your evidence, determine your credibility, at least be able to observe you how you're answering the questions. But with a PRA officer, with the pre-removal risk assessment application, it's only a PRA officer that determines it, not a panel member like a judge. So an officer will actually be looking at that case. It is a paper-based application.
Most of them are paper-based. Very few.
Very few. You will even have the opportunity to have your case heard in front of a PRA officer. But most times it's determined based on the paper, right?
Yes.
Exactly. Based on the paper that you submit. So that's why most of us, legal practitioners, have concerns about this legislation that was passed because we think it is unfair. It doesn't allow for a determination based on the merits. The appeal process is there's two layers where you can try to remedy the issue if you're refused, but with this it's just one level that you can go to, which is the federal court.
It doesn't conform with international law.
And doesn't conform with international law because the international law talks about if you genuinely fear persecution, you should have a refugee determination hearing. But this one, they're saying you're not going to have a hearing. You're just going to have a PRA option, pre-removal risk assessment option. So I've talked about three things now. Today, I've talked about calendar cutoff, 1 year after June 24, 2020. If you've stayed there for 1 year or more, you're going to be caught by this if you make a refugee claim. If you've left, you came to visit or you came to, to work and then you left and you even for a short period and then you came back and it's been 1 year since the first time you entered after June 24, 2020, it doesn't matter. And you now fear for your life because something happened back home, right? You will still be caught by this legislation. That's the first thing, the calendar cutoff. Then I talked about the option of if you're caught by it, they may offer you a procedural fairness letter. Explain yourself, basically, if you can call it that, a PFL letter. Consult a lawyer immediately to help you to respond to that procedural fairness letter. Sometimes it won't be a procedural fairness letter you will get. It will be a conversation, even a conversation, right? Yeah. With the officer. It can be a conversation with the officer. And then the officer will say, you know what, you're caught by this, and then give you an ineligibility letter. Or it may just be a letter that you just receive in your portal that you're ineligible. When you receive that again, you have to consult with a lawyer who can help you to deal with that at the federal court. Then the third thing I talked about is the work permit option. Because you've been found ineligible, the government doesn't want you to be, go on public assistance. They want you to still be contributing to the economy. That's the irony of all these things. They still want you to be working and contributing to the economy, and of course not be a liability to yourself or to the society. So they said, under the policy that was drafted under this stuff, they said you can apply for a work permit on the basis that I was found ineligible and I'm still waiting to be called for PRA. Then we also talk about pre-removal risk assessment, which is the PRA. That option is available to you when the officer invites you and says, you know what, Mr. John, we want to meet with you. That's CBSA. Canada Bar Association invites you in and says, we want to meet with you. And then you go there. Okay, we want to offer you PRA. If they offer you PRA, pre-removal risk assessment application, please make sure you accept it. Don't say, I decline. Make sure you read that piece of paper. Don't sign, I decline. Because that may be your option of staying here in Canada. Because if you're successful in that one, you will still be conferred conversion status or protected person status. And then you'll be able to apply for permanent residence. You need a lawyer to assist you with that as well. Okay, there's strict deadlines that apply to that. Make sure you meet those deadlines, you don't miss it. Okay, so keep those in mind, right? Yes, exactly. So those are basically the things I want to talk about on this one. Of course, there's another ineligibility criteria, the 14-day border entry rule. Really, there's that's not happening much these days because they've closed the border. But basically, claims are ineligible if made more than 14 days after entry Canada between official ports of entry along the Canada-US border. So some people enter through the Canada-US state border stuff. So if they enter and they've been here for more than 14 days and they haven't made their refugee claim, then they'll be ineligible. Yes. And if made more than 14 days after entry.
But we don't see more.
We don't see much of that.
Anyway.
What we see is the first one, that the calendar cutoff that I talked about.
So thank you very much for that. That's a good overview of the stuff of that whole bill, especially with regards to ineligible refugee claimants. The only thing I will add to it that my brother really covered of a lot of stuff there, but the only thing I will just add to it is that when it comes to one of the key difference between refugee claim and pre-removal risk assessment is that when you make a refugee claim, they can't remove you from Canada right away. So, and if, let's say it was refused and you go for an appeal, they can't still remove you right away from Canada. So Canada Border Services can't remove you. And let's say they refuse at the refugee appeal division and you go to the federal court, they still can't remove you at that point, right? If you file your federal court. But with regards to a PRA, once you file it, again, they can't remove you. But if you are refused and you go to the federal court, they can still make a move on you to remove you from Canada. So again, that's one of the challenges that we have with this old bill C-12, because we think that it doesn't offer as much protection as the refugee convention regime. Okay, so that's basically what I wanted to add, but you covered a lot of this stuff. So let's move on to the next item that we want to cover, what we're saying, at least in our line of work. So we've been hearing a lot of phone calls from people that finish their university and stuff and their college in specific programs, and they're applying for post-graduation work permits. There's a major issue that is going on right now, and we just want people to be alert to that. I don't get many of these type of cases because people can do it most of the time. They can do it on their own. I get a few of these cases each year, but I'm just hearing. I'm doing a lot of consultation on this stuff, and it's coming up over and over and over and over again. So I just want you to be alert to that. So there's the language requirements with regards to post-graduation work permit. So you have to meet certain benchmarks, Canadian language benchmarks, whether it's French or English. So and they have some approved tests. So most of the students know about this. So I think, but the problem is this: when they are applying on their own, so they answer some questions on their portal, and then it generates a checklist. So, and in that checklist, for some reason, it's not generating a link or a section where you can upload your language test. So most people are not uploading their language test. As a result, they will then be refused, and then there's like, what? I didn't see that in my document checklist that was generated by the system. They didn't ask me for that. This is unfair. I think it's unfair, but guess what? The problem is it still doesn't matter. They've refused you. You didn't provide the documents. So what I do for my clients that retain me, I submit my applications through my own portal, lawyer portal. So it doesn't generate it in my own portal too, because I select what I need to select. So I know the criteria, I know language test is a requirement, and I know there's no section for that. So I just check mark client information box. Then I upload the language test under that client information form, and then I reference it in my own cover letter. So in your portal, there's also the client information box. Check mark that, upload it with an explanation letter that there's no box for the language test result. However, I know that this is a requirement, so I'm uploading it under this client information submission category, and then scan that letter with your language test and upload it. So that's one scenario that we're finding. So some people, most that have called me, they missed that. They didn't include their language test. Some included it, but for some reason, they didn't submit all the client information, but it's still as part of their application. Or they were told, maybe some friends told them, or they realized that, oh, I didn't submit that language test. They submitted it through the web form.
Before a decision is made.
Before a decision is made. If you did that, before a decision is made, if they refuse you, we can deal with that type of issue too. We're going to ask for reconsideration. We're going to provide the proof that it was submitted before a decision was made. I've had that situation too, and I was able to get the post-graduation work permit 3 years for that client as well.
And it is very important to keep a record of the web form submission that you submitted. Keep it, please.
Keep it, because you will get an automated reply that you submitted it, and then they will send you a second email again that will say this is what you submitted. So keep those things, because if we have to ask for reconsideration, we're going to need that. Okay, so that's second scenario, like you submitted, you realize, and then you submitted through the web form. Then the third scenario is you just lumped it with other documents, maybe your transcript and stuff like that. And for some reason, they didn't say it. If we can prove that you included that, we'll be able to ask for reconsideration too, and most likely they will agree to it. Although my approach will be, I ask for reconsideration, and I say go to the federal courts. So you ask, why am I asking for federal court? I'm trying to put pressure on them. That if you want this federal court matter to go away, you better address my reconsideration request. Because on average, it can cost the department an average of about $5,000 to defend a federal court case. So I don't think they want to spend money on that. They will rather deal with my reconsideration request, which is a valid reconsideration request, and make it go away. Right? Then I don't need to pursue that. I can just discontinue that. It's a strategy that one can employ as a lawyer. Right? So, but let's say you didn't submit it at all, and then you quickly went to do the test. And then you say, you refused my stuff, but I've done my English test now. Can you reconsider? The likelihood of that succeeding is very minimal. I've never seen a case that was reconsidered. They will say they maintained their decision, because before the officer at that time, when he or she made the decision, there was no English test. You didn't submit it. So that decision is fair. Square. That's the law. Okay. So keep that in mind. Don't be one of those cases.
Yeah. I'm just sorry to interject, but one thing that I also noticed is from people calling is that sometimes they've done the English test and then they don't actually load up the English test. They include they include a page whereby test results for let's say IELTS, and then they're expecting the officer to maybe log in to check the results. No, don't do that. Get the actual test results that shows your scores for each level. Is 4 levels. Showing for each level, and that's what you're going to upload, the actual result. Please don't make that mistake. I've seen that too much, and it breaks my heart. Let's make sure that we're uploading what we should upload. Upload it. Clear copy. Uploaded. Very important.
Okay. So it's very like, again, it breaks my heart too, because you've spent 4 years in university, for example. You spend probably about 100,000 in school fees. You spend about probably 80,000 over those 4 years. And then this work permit that you're supposed to get, you just made a boo-boo. And that boo-boo is not rectifiable, right? So sometimes it's not rectifiable. So you have to make sure that you address these things and be just diligent. If you don't know what you're doing, honestly, just get a lawyer. Pay. How much are you going to pay the lawyer compared to what you've already spent over the last 4 years? Don't be cheap. If you don't know it, get somebody to help you. This is not what you do on a daily basis. Okay. So if I need a doctor, if I have a headache, I'll go to a doctor. I won't say I want to fix my problem by myself. Okay. So let's move on to the next item. The next item that I want to talk about that people don't know about this program. So I know, like, I'm Nigerian, I know Nigerians, Ghanaians, they are one and the same as far as I'm concerned. So although we argue about our Nigerian jollof and Ghanaian jollof, which one is better? I think Nigerian jollof is better, but I don't want to get into trouble today. So because I've been preparing Ghanaian on this,
we are outnumbered.
we are outnumbered today. So, but I think we are the same. So we are very, as far as I'm concerned, we're very brilliant people. We can do anything, we can achieve anything. So we are not limited by anything. So there's what we call the French Mobility Work Permit Program. So people are saying, I want to extend my work permit. Oh, my 3 years work permit is finishing. I haven't been called under the Express Entry Program. I have not got an invitation. I've not done this. I've not done. Okay, no problem. So because you are smart, one thing you can be doing, if you have an employer you have a good relationship with your employer, the employer wants to maintain you. You are outside of Quebec. You speak French language, or you can study the French language, then go and do the French test. The employer can hire you without an LMIA, Labor Market Impact Assessment.
You don't need that.
They don't need that. All they need to do is submit something, a form, to the employer portal, telling them that they want to hire you under that program. No LMIA involved, Labor Market Impact Assessment, that you need. Most people need that to be able to apply for work permit, if it's a closed work permit. So if you have a good relationship with your employer and you've started studying right now French language, just get the minimum score.
It's very, very low.
I don't cram this on my head, but it's very, very low. And it doesn't have to be a knock 0, 1, 2, or 3. It can be any knock tier. Right? So do the French test. You meet those requirements and stuff, and then they submit an offer of employment through the employer portal. It costs your employer probably about $200 and something bucks, $230. You get that, then you use it to apply for a work permit.
We've had people that we've been able to help with that.
I once had a client. They came to me and I can't, actually from a French-speaking. Is it French? Yeah, French-speaking country.
Yeah, mentioning
African country. I can't mention names and stuff. They were already out of state, but they were within the 90 days to restore. So I said, have you heard of this program? Oh, I haven't heard of that program before. Oh, that's that program. Do you have a good relationship with your employer? Oh, yeah, I have a good relationship. And they want to keep me. They're just saying, what can they do to help me? I said, okay, go and speak to them. There's a program like this. Lord and behold, we were able to get it done. Restore the person's status for work permit, got them another 3 years to stay in Canada.
At least within those 3 years, they'll be able to sort themselves
They'll be able to sort out their immigration stuff because they want to stay here permanently. But that buys them time. And I'm seeing a lot of Nigerian people too that are doing that. They're learning the French.
Yes, right? A lot.
They're learning French and they're succeeding. And they're immigrating and becoming PRs. Because under even the Express Entry Program right now, you can get points.
There's more preferential treatment.
There's more preferential treatment for people that have the French proficiency. So maybe this is the time that you can sort of push yourself a little bit. You want to stay in Canada? Maybe this is another thing you should be thinking about. So there's the French Mobility Work Permit Program.
And one thing that I tell people is, sometimes, if you say you want to get a French tutor here in Canada, it may be expensive. You may not be able to afford it, but you may have, someone back home who is a French graduate, right?
Or French teacher.
Or French teacher. You pay them, in their currency, cedis, or if it's in Naira, you get one person in Nigeria that speaks as a French language graduate, and will be teaching you over Skype or Zoom or FaceTime, and then you gain the skills that you'll be confident enough. Maybe within a few months, you're able to then go and challenge the exam, right? Then there's Duolingo that you can use to complement that private tutorial that you're receiving, right? So you have to be willing to invest in yourself. That's very important. I remember when I finished law school, I had to article. And
article, by the way, is like apprenticeship.
Apprenticeship. You have to do that before you can then get called to the bar. So I was finished at the top 10% of my class, but despite that, this was a tough labor market. It's not it's not easy for a minority at that time to get that articling position. What I did was I offered my services for free to a lawyer, and I did that for straight up for 10 months, right? I wasn't paid for it, but I knew what my eventual goal was going to be. So it's about self-development. So and when I got called to the bar, again, that became history. And this is where we are 21 years later. And I have articled people over the years and paid them, right? And nobody could pay me, but I was able to pay for others. So, but that's our life is. So be willing to take risks, be willing to, to invest in yourself. At the end of the day, when everything turns out right, you won't remember all those things to become history. Okay.
So we're now at our 4:32 p.m. So I think that we have a lot of time to answer questions right now.
And I'll let Samuel take the lead in terms of telling us, which questions are there, and then we'll take.
And the questions that we are not competent to answer, we'll tell you that we're not competent as well too. So that's just who we are. Okay.
Okay, so thank you very much for the presentation. If you have a question and you want to maybe open your mic and speak, raise up your hand. There's a hand icon here. Just raise it up, and then we'll know who comes first and who comes next. I'll call you according to that sequence. But we have some questions in the chat, and I'll start with those as we wait for those who want to speak. So there's a question from Priscilla. It says, can LMIA closed work permit be extended, or the employer needs to apply for a new LMIA for the employee?
That's a very good question. So LMIA, although I don't do LMIAs anymore, years when I first started, I used to do a lot of LMIA, but I don't do LMIAs anymore. So, but I'm still knowledgeable about it and stuff. So LMIA usually has a start date and end date. So basically, if the LMIA, your work permit is coming to an end, LMIA is no longer valid and stuff, the employer has to get a new LMIA to be able to, so that you can apply for an extension of your work permit. So keep in mind, if you, as a general information, LMIA is tied to your work permit. So the LMIA, you have to have a valid LMIA to be able to extend a closed work permit with the same employer.
Okay, thank you. And then there's a second question from Deborah. It says, with the recent restructuring of the Ontario Immigrant Nominee Program, or NIP, how should international students and graduates realistically position themselves to remain competitive for provincial nomination in Ontario? And then maybe as you answer it, you can also tie in other provinces. We don't want to limit ourselves to only Ontario. Thank you.
The OIMP stuff, I don't follow much of it. The ones that I do mostly for OIMP is the master's program, whereby the person has completed the master's and they've done their expression of interest under the provincial stuff, and then get nominated, and then they come to us and then we help them to apply for the permanent residence. But in terms of positioning yourself for permanent residence, I mean, a student should not limit themselves to just one option just because you get selected under the OIMP and then you apply for the you apply for that permanent residence under that program. That means that doesn't stop you from applying for the express entry. That doesn't stop you from pursuing other options that may be available to you. I always say, don't put all your eggs in one basket. I once had a client that had 3 options because after doing the consultation, I realized that there's 3 options available to this individual.
A lot of them equally strong.
And all of them equally strong. And he said, what should I pursue? I said, well, let's pursue all 3 if you can afford it. Each one is a separate retainer agreement and payments. If you can pay my legal fees for all the 3, for each one, I'll pursue it for you. But even if you can't afford it for all 3 and you want me to pursue one of them, I'll pursue that, but make sure you pursue the remaining 2 on your own because they're equally viable options. And then when that person came, when things were rolling along, then we had 2 that came through and he said, should I drop this? I said, no, you have a bird in hand is better than 10 in the bush. So let's first we pursue all 2. And then when you get landed as a permanent residence, then you can then write the other whatever, and then ask them to stop that because you've already landed as a permanent residence, and that's exactly what happened. So pursue all options, but to better know what your options are, it's very important to consult an immigration lawyer. I once had a client that had that express entry option, provincial nomination option, and family sponsorship because they were married to a Canadian. So and they were asking me, what should I do? I said, well, if you can afford it, let's pursue whatever. I think the family sponsorship is a good option, but hey, God forbid, relationship breaks down, you're screwed. So along the way, so let's pursue all options. And that's exactly what we did. And then, of course, the relationship survived and we got it through that means, but I wouldn't put all my eggs in one basket because I have no bird in hand in the first place. So, but to know all your options, it's better to consult with an immigration lawyer who knows their onions.
Yeah. Okay. And I think you really answered the question really well. It's like going to the market. There's many rules that lead to the market. So don't just chase, this is the only way I can take to the market and stuff like that. We don't deal with most, like my brother said, we don't deal with most a lot of provincial nominee programs. And I don't think there's any lawyer that can claim to know all the provincial nominee programs in anywhere in Canada. So be wary of that if someone says they can access all your provincial nominee options and stuff like that. But provincial nominee programs are there, but I can't profess to know everything about provincial nominee.
From what I understand, Manitoba has some favorable provincial nomination programs. Saskatchewan has some favorable provincial nomination programs. Alberta has some favorable provincial nomination programs. Even Nova Scotia. So you have to do your research and see which one you may qualify for, and then also explore those options as well. There's even rural nomination programs.
There's a rural northern immigration RNIP or something like that. So I once did 1 or 2 of those type of applications. They were successful. It's very interesting too.
Yes, Timmy, Standard Base,
all the small communities.
Yes.
Yeah, so the floor is still open. If you have a question, you can open your mic and start, or raise up your hand and I can call you. Any questions from our participants here? Okay, I have a question. So for students who transition into workers and looking for, maybe they are in the express entry pool, but currently there are a lot of changes in the express entry in terms of the priority areas. So the jobs that are being called or they are being given the nominations, maybe your job it doesn't fall within those specific knocks. What can someone in that situation do? They've already finished school, they already have their post-work permit. Maybe 3 years, they've done 1 or 2 years, and their knock doesn't fall within the priority areas.
Okay.
What should such persons do?
Okay, that's a very, very good question. And there's a number of people in that particular group right now. So I will talk from the big picture and then I will narrow it down a little bit. First thing is that, and the truth is, as far as sad as it is, Canada is restricting immigration right now. That's the honest truth. And history has shown that in Western countries, tend to restrict immigration when they have economic problems.
Mm.
It's almost like it's the immigrants, but they don't say, but we know that they will tend to restrict immigration when there are economic problems. That's how it is. If we look at United States, they are restricting immigration. If we look at Europe, they are restricting immigration. If we look at Canada, they are restricting immigration. And I think a lot of this climate is caused by Trump, because and most countries now are now leaning to rightward. And I think Canadians too, from my perspective, are leaning a little bit rightward too, because of rising cost of living, food, housing, even the schools for elementary, high school, they are overwhelmed. So infrastructure needs and stuff. So there's a lot of pressing pressures on the system itself. So, and we know that that's probably why Trudeau was kicked out. I'm not a politician, but I study politics as well too. I got a bachelor, I have a bachelor's in political science. So, and then Carney came. Carney is a liberal, but so I believe is in the center. And I am, again, I'm not a politician, but I like Carney, but at the same time, is under a lot of pressure not to bring in more people and to more or less the temporary workers leave. You've studied, go back to your country. Workers go back. So that's I think that's where the climate is right now. So that's the big picture. So now let's talk about you are in the express entry. Nothing is happening for you. What do I do?
No movement.
No movement. But you have to, again, I'll come back to what I said earlier. Can you study French? So you can get more points. And then there's a lot of people, there's that French, there's more preference to people that speak French, understand French, read and write, listen. If you really want to stay in Canada, and you still have a lot of time, especially, start studying it. You just have to score a few more points. I can't tell you off the top of my head what the points are, but get in the pool, get more points, update your profile. That's one. Are your English tests at the level it's supposed to be, not just the minimum? You got 6.5. Don't be happy about 6.5. We are from English-speaking countries, right? The British colonizers. So we should be at maybe 9, 10. Try to go and redo the test if you have to redo the test.
Try CELPIP.
If IELTS General is not working for you, then try CELPIP General. Maybe you go to Scott. I've had a client before that I said, I'm not getting. I said, try CELPIP. Just see whether. And they tried CELPIP. Lord and behold, they got more points. They got out of the pool. Invitation.
They updated their profile.
The difference between a person that is selected and a person that is not selected is just 1 point sometimes. So if I want to use 800 points to select someone, and someone scored 799, you're not selected now. It's just that 1 point that caused you the problem. So every 1 point counts. Then, if you're married to a Canadian or a permanent resident, if that's your status, I'm not saying for permanent residence purposes. So I'm not saying go and get married for permanent residence, but you have to be in a genuine relationship and not primarily for permanent residence purposes. That may be an option for family sponsorship, spousal sponsorship, common law sponsorship. Some people don't even know they're living with a Canadian, they're in a genuine relationship, they're common law. They don't even know that they can do sponsorship. And they do a consultation with me. And the guy is saying, I don't want my wife, my partner to leave Nigeria, to live for Nigeria or to live for Ghana or to live for whatever. Then I start asking questions. I said, do you know that you have this option? Oh, really? Really? Ignorance sometimes is a problem. Consult a lawyer, right? Don't be cheap. ChatGPT can't solve all your problems. People consult ChatGPT instead of consult a lawyer. ChatGPT is based on large language model. So that means they've dumped everything that are in there. In the sink. They're business people. They dump everything inside. So it can't solve your problem. Even if you start talking to from ChatGPT from morning till night, it can't solve all your problems.
Consult with a lawyer. Like my brother, I would say he has a lot of cases in his head. He can be quoting cases and paragraphs up the top of his head because sometimes he can sit on the weekend and read 40 cases for fun. He doesn't have a case that he's dealing with, but he's reading it for fun. Right? ChatGPT may not know that case. It can't solve your problem. So consult a lawyer, get advice so that they can. When someone consults me, what do? I ask a bunch of questions. What is your name? What is your date of birth? Are you married? Are you in any dating relationship? Are you divorced? When did you enter Canada? What have you applied for? What is this? What is that? What is your background? What about your parents? About you have children? Do you have what are they doing? This, that. I ask him, God, what's your community involvement? Do you have any medical condition? Do you have this? Why am I asking all of these questions? Just like a doctor, the doctor has to ask you questions so that I can know what to prescribe for you. Can you trust a doctor that doesn't ask you questions and just say you need codeine? That is why you have to consult. You don't have to consult my brother and myself. It doesn't have to be us. We're okay. We don't need to be consulted. Consult someone that you trust. If you think that I can give you good advice, you can consult. If you think that there's a better person that you can consult, but consult somebody that is experienced.
Not your friend, though.
Not your friends, because your friend is not an immigration lawyer. John did it this way. Why didn't mine come out that way? Well, John may have another issue that is your background. Or John may not even tell you all the story of how he got it. Because he doesn't want you to know, right? I keep on using John. John is in trouble today. So, but so I don't know who John is, but he's my fictional character. Anyways, so basically,
so that's one option, exploring your option. Again, if your stuff is going to expire soon, your post-graduation work permit is going to expire soon, you may be able to say, you know what, I'll just go for my master's at this time. Get your school admission, change to a student, right? And then go for your master's, and that may open up the OIMP route for you. If you're a full-time student, make sure you're full-time. In any of your programs that you're doing, make sure you're full-time.
Always be full-time.
Always be full-time. That's very important, or else you will be ineligible
for some programs.
So go for your master's if you're able to, or go for your PGD. Just stay there because you have your express entry going on. You don't want to fall out of state. If you can't afford it, go for further studies. Maybe you want to change to a visitor record. You can change to a visitor record at that time to, so that you are still in status while you're pursuing other immigration programs that you
get an LMIA.
Or get an LMIA.
Right? Be ready to move to another province. Don't say, oh, I can't leave Ottawa. I can't leave Toronto.
My friends are here. Right? So if you have a PGWP and then you get a job in Manitoba or Saskatchewan or whatever, look at their programs and see which avenues you can use to get to permanent residence. It may be easier there. So these are things that you have to consider. So if all options are lost and you happen to fall out of status, then reach out to us. There may be option for humanitarian and compassionate application for permanent residence, right? So there's no guarantees of any processing time. People have
no guarantee of processing time, no guarantee of outcome. We just do our best. That's it. We do our best in every single case. So that's a very loaded question and a very important question because there's a large segment of people that are actually in that situation right now.
So thank you so much for that question.
Thank you very much. So we still have 10 minutes. If you have questions, you can unmute yourself and speak, or you can raise your hand and I can call you. So we still have some time. Ask your questions now. This is the time. You have lawyers, barristers around, immigration lawyers, and your questions will be answered professionally.
Hello, Sam.
Yes, Christopher.
Yeah. Good evening. So I just have a little concern or a question I want clarification on. Assuming I have my partner with me here, and I have just completed school. So the next step for me is to get a postgraduate work permit. But currently the law says you should be employed in one of the NOC tiers, like the critical sectors, to get your partner to also get the extended work permit. And I currently find myself in neither of those critical sectors. What can I do to help my husband get the the work permit for the extended number of years that I'm also going to get, which is get 3 years?
So that's a very good question, but I won't answer it directly. And don't take this as a direct answer to your personal situation. So I'll just talk about what IRCC says that you need to do, and what is available on their site and stuff. What IRCC talked about was that for their company spouse, for their company spouse to be eligible to apply for a work permit, open work permit, the principal applicants has to have a job in a tier 1, 0, 1, 2, or 3. So in that situation, it requires that you include an employment letter that is detailed, name, job title, start dates, hours per week, duties, and if the employer knows the NOC code as well or whatever, put the NOC code as well. Put the pay, it asks for the pay stubs as well. I always say put at least 4 pay stubs in there to show that you're working there and stuff, and include it as part of that. And of course, so if your company spouse is applying at the same time, you want to make sure that those documents that I just mentioned, including the marriage certificates and your immigration documents that you have, is included in there as well. So in a situation where the spouse doesn't have, of course, you have to make sure all the other requirements are met as for the principal applicants. I can't go into all those details. Just check them up. For a situation where the principal applicants, i.e. the person that that came in and the other one accompanied, the principal applicant does not have a job at the time that they're applying, or the job doesn't even fall within that NOC tier, you may want to look at situations whereby the accompanying spouse may want to apply for something other than the open work permit at the beginning, so that they can continue to maintain valid temporary status in Canada. And then once you get your work permit and stuff, and you get a job with the required, the qualified occupation, then the accompanying spouse may then apply on the now, saying that I want to get an open work permit on the basis that my spouse has a PGWP, post-graduation work permit, is working in a qualified occupation, and yes, he had the proof that I'm married to that person or in common law relation with that person, and that these are the proof of employment as well. That will be the strategy that I may employ in that case. But every situation is different. So to get individualized legal advice, then you have to consult with a lawyer, whether myself, my brother, or another qualified immigration professional.
And please, don't forget your children. Most people always forget their children in the process. It shocks me.
It shocks me.
It blows my mind. We're extending theirs, but they forget to extend the children. So, I mean, that's just not.
That's not right. That's not right. How can you forget? It's like, oh, I didn't know that they need to apply for. Why wouldn't you know? It is not. They don't have status here. It's a privilege.
You're not Canadian.
You're not Canadian. You're not permanent resident. So you should be applying for something, because you apply for something to get in here in the first place. They have status. Then if their status is expiring, you should be applying to extend them. So don't, people that with families, don't forget to extend your children as well too. It's very mind-blowing that I would have people that have valid status, the parents, and the children are out of status. That is, and I think sometimes ignorance, but sometimes it's being cheap. Why do I need to spend another $200 or $300 to extend the children? They won't let them stop going to school now.
Add that was a discussion. I don't understand that, and I can never understand that. Okay. So, any other questions, Samuel?
Yes, the floor is still open, but maybe on that same, I think you mentioned that assuming you're a student who is trying to transition to PGMP, you need a letter from an employer in that specified NOC or tier. And
not that, in that situation, they don't need a job letter. The PGWP applicant doesn't need a job letter.
Okay.
But the accompanying spouse has to be able to show that my PGWP wife or husband has a job in NOC 0,
okay,
1, 2, or 3.
Okay, so
if the person is single, for example, now, and they're applying for post-graduation work permit, they don't need it. They don't need a job offer. It's not a requirement for post-graduation work permit applicants. Even that was back in the days. That was back in the days. And if you're married too, even the other person that's applying for PGWP, one of his requirement or a requirement doesn't include a job offer. But if the accompanying spouse is dependent on that person, I want to get open work permit, I wants to work. We need that one.
Yeah. So my question is that, so maybe the woman is a student going to postgraduate work permit, and then the man is the accompanying spouse.
Yes.
He has to show that the woman has a job in tier 0, 1, 2, 3.
Yes.
Do they need to also show that they've received, like the woman has received pay stubs, because maybe he just got a job and then want to apply for the work permit for both of us?
Yeah, the department, what I've done for all my clients in that type of situation, I will include the job letter and I will include the pay stubs. I usually include 4 pay stubs in those type of application. I've not had a situation whereby they just got a job. But even if they just got a job, still use that to, if you're still within the timeline,
okay,
and you can wait to get 4 pay stubs, that's fine, wait. But if you can't wait to go for it because you don't want to fall out of status yourself before you apply for PGWP, or you don't want your wife or husband to fall out of status too. So if you can wait a little bit just to get all those stubs, then wait, no biggie. But if you can't wait, if the time period is so short and all I have is an employment letter, I will submit that with an explanation letter. That's what I would do. And even when you do that, then the application will take some time to process, right?
Yeah.
And as soon as you have your 4 pay stubs or 2 pay stubs or whatever, send it by web form and just say, please use it to update my application.
Okay. Okay. Thank you very much. We have 2 minutes. Anyone has a quick question? Otherwise, we would thank barristers Kehinde and Taiwo from Ladley Ray Law Office. So they just added their contacts details, phone number in the chat, and also their web email address. And I think it's not email, it's a website, but I have the email address. So if you need the email address, just contact me, and I have their phone numbers also. Yes. So yeah, if you want to book an appointment, yes, call them or book an appointment via the website. I think you should be able to book an appointment there. So Priscilla is asking, do we book an appointment? Yes, if you want to have a consultation.
Anyone can book a consultation on our website, ottawaimmigrationlawyers.com with an S, ottawaimmigrationlawyers.com. So you book it online. You have the option of 30 minutes consultation or 1 hour consultation. The prices are there for the consultation. And usually when you book it, it will appear on my calendar. You will receive an email on your inbox. If you don't see it in your inbox, check in your junk mail or spam mail. It will tell you the payment instructions. You make the payment, and then your appointment is confirmed. So just go on the website, ottawaimmigrationlawyers.com, and then follow the instructions there. You will see all the information there. And if we don't remember the website, just put in Twins, Immigration Lawyers, Ottawa. There's only one of us.
Yeah. Thank you very much. So this seminar was brought to you by the Ghanaian Association of Ottawa. It's part of our Community Impact Series. We have a seminar each month. So this month we focus on immigration. hopefully next month we'll have something to bring to all Ghanaians in Ottawa. So thanks everyone for joining, and we appreciate the time spent with us by lawyers, Olalere, the twins. So if you have any questions, their contact details are in the chats, and then you can send them an email or call them or book an appointment. So we thank everyone here, and I think we are right on time. So thanks everyone. The recording, I'll share the recording on our various pages so that you can rewatch. And if you have any questions that you didn't get, or you can just rewatch and then send a consultation request to the twins. Thank you very much. Have a wonderful evening and a wonderful weekend.
Thank you everybody for coming and attending.
And we wish you the best.
I wish everyone the best.
Thank you.
Thank you.